Okay. Hopefully you can hear me okay and audio's okay, and we'll go ahead and get started. So again, feel free to put on the Q&A portion of this webinar on the bottom. You can always put in some questions and we'll try to answer them as we go along. All right. So the first thing that we always kind of put out there is that there are a lot of things that people don't understand in terms of the statistics that can happen when it comes to just life. And what are those things that are kind of unusual or don't know about, right? So the statistic I like to share is about lawsuits. There's over 10 million lawsuits that are filed on a yearly basis. That's a lot of lawsuits. We also talk about how people file for bankruptcy. Over 400,000 people file for bankruptcy on a yearly basis. That's pretty high. The second topic that I think people don't realize is out of control is that we have the highest divorce rate when it comes to the world in general. And what do most people think that is? People say 50% is their guess when I talk to people. But often what I found out recently is actually it's up to 55%. So more than half of the marriages in the United States end in divorce. The other statistics that is very scary is how much long-term care can be. It's quite expensive. So you can see how the median cost of a nursing home in this area is about $142,000 a year. That is a lot of money, right? That your savings will go down really quickly just from that. And then it's about $12,000 a month. So if you can think about how that will kind of reduce your savings, how quickly it would be reduced just by staying in one nursing home for 1 year. The other statistic that's pretty scary is that there's a lot of caregivers out there that provide aid to our friends and family, and mostly it's children certainly taking care of their parents. 53 million to be exact. And most of those people are certainly not paid type of caregivers. So I would say at least, I don't know, half to 3/4 are unpaid. They're family members, they're friends, people who are taking care of other people. The ones that are paid, though, can be quite expensive. My clients have spent anywhere from, say, for in-home care 24/7 is about, I would say, $10,000 to $15,000 a month on in-home care. So that's caregivers. Of course, when there's poor estate planning, the lawsuits are out there, people fighting over money and having those grievances from childhood come up, and that's pretty common as well. Most of clients, come here and they have one of 6 concerns, if not all 6. So we're going to touch on all 6 today. First is they want to pass on their hard-earned assets without the government being involved or the courts being involved. So certainly that's super important to avoid having to go through court. Number 2, they're concerned about paying more money to Uncle Sam. We all pay a lot of money for Uncle Sam, and we should definitely not have to pay any more when we pass away. So we want to avoid that. Number 3 is they want to avoid from going broke from nursing home costs. Like I mentioned, it's about $142,000 a year, so we don't want to spend all of our money dealing with that. After they're gone, families are worried about their family members getting taken advantage of by predators and creditors. When I say predator, I think about people who scam. And we know there's a lot of scammers out there. The one that I bring up a lot is Bernie Madoff. He is very much the poster child of people who scam. He scammed a lot of rich people. Billions of dollars was gone because he told them that he would help invest it. And really all he was doing was what was considered a Ponzi scheme, spending that money and using it for himself. Number 5, after they're gone, we want to avoid this. We want to avoid from family members fighting over things because it really should be a time to bring the family closer, but yet it can tear them apart because it's regarding money. And it's because, again, there's a lot of old grievances that haven't been ironed out when it comes to dealing with just the family dynamics. And last but not least, family members certainly want to pass down their money and property, very important, but they also want to pass down wisdom and values and life lessons for generations to follow. So very important to do that as well. So you might have answered the call to come to this webinar to be able to deal with some of these concerns. Some of them, maybe all 6 of them are in your mind. So hopefully we'll be able to answer a lot of these questions for you. Is knowledge enough? This is similar to like when people say, oh, it's great to know all this information, and you're going to certainly be educated today, but our real focus is getting into action. So if you don't have an estate plan, definitely give us a call. Let us know what's important to you so we can take action. Otherwise, there's no point in having knowledge if nothing's getting done. So I do want to introduce myself. I think it's important for people to know who I am because we are the estate planning attorneys here. I'm an attorney since '97. I've been doing this a long time. I have a master's in accounting as well as a law degree. One of the things that I'm very proud of is I'm part of a large organization of lawyers since 2003. It's called the American Academy of Estate Planning Attorneys. Why I introduce myself? Because I think it's important for people to know why I do what I do. As you hear my story and hear this webinar, you'll realize that I'm pretty passionate about this topic. I am an immigrant. I came here from the Philippines when I was 5. So we came here just like any other immigrant, pretty much with not much in our hands and really just working towards the American dream. My mom is a nurse, and we received her approval of a visa when I was, I think, 4, and basically they applied for that visa even like years before I was even born. So of course, my mom and dad had a big decision. Let's go to America and do that. And that's a big decision. I don't take that for granted. So when we came to America, it was the typical, again, immigrant story, but I am so passionate about this topic because I see all of you, whether you're a recent immigrant or 4 or 5 generations in, the American dream is super important to everyone. I know how hard you work for your money, and we want to make sure it's actually given to the right people and passed down to the generations. So I'm very, very passionate about this topic because I know, looking at these pictures, I'm like, I remember being a kid coming to this country, getting all excited about snow, and yet I think back what a huge, huge sacrifice my parents had to make in order to make that decision to come to this country. So I want to be that person for you. I want to be your trusted advisor because I believe in you and your family and your American dream. Our valued resource, I mentioned the Academy earlier, and I said we're very, very proud of this because it's pretty exclusive. There's only 2 of us in this area, and we are a large organization of lawyers. So I've been with them since 2003, and basically we take care of our clients just like a lot of other estate planning attorneys in the country. So there's about probably 175 law firms as part of this academy, and we continue to have our education from them, our marketing from them. We have a lot of guidance from them. So even though we're small here in this area, we feel like we're part of a larger firm because of our academy membership. Money Magazine has certainly kind of highlighted the academy. So they say if you ever needed anything regarding an estate plan, go to the academy website, which is a huge honor to be recommended by publications. The other company or person that has recommended the Academy is Susie Orman. I know many of you have heard of her. And basically, she's the one who has told her readers in this book to go check out the Academy website in case you need a good lawyer. It's the only website that's even referred to, and we're proud that she did that without even, there was no advertising costs. It was just the website that she recommended. If you are on social media, absolutely follow us. There's a lot of information that we offer in social media, so definitely take a look at that. So we want to congratulate you. So you're coming to our webinar to discuss this topic, and it's not usually fun topics. We're talking about death, we're talking about taxes, talking about nursing home costs, why families can be torn apart, and then sometimes your plan doesn't work, right? And you might be wondering how. And so we'll talk about that quite a bit. Number one reason, right, this topic is kind of not addressed is really procrastination. Most people don't think they're going to die anytime soon, or I'm going to wait till I'm 70 years old and I'll get it done then. But we all know that we don't have a crystal ball, so we have no idea when our time is up. I always bring up, celebrities, right? We hear about them on the news. And so I think about even our 80s star like Whitney Houston or Prince or Michael Jackson. None of those people actually planned properly. They didn't create a good estate plan because they didn't think they were going to die anytime soon. So procrastination is our number one reason. The other reason is people are just confused. Confused that there's so many just areas of knowledge that you can find from the internet or social media or books, and it gets confusing. So hopefully we'll be able to understand, we'll be able to educate you today to understand the basics of estate planning and why it's important. Okay. So we promise to discuss why traditional planning has failed most Americans, why estate plans may not work, the benefits of estate planning, and then certainly identify the most critical part of estate planning. So we will answer your questions towards the end, so just letting you know that. So just jot down your questions, that would be great. So ready for an epiphany. So an epiphany is really just seeing the world in a different way that you're used to. So seeing the world in a different way means, how do you determine what is wealth? How do we give it to the people at the right time? Because we're all different. We have different ways of kind of defining ourselves, and we're all individuals. So how do we take these emotional anchors of our lives and really pass it down through estate planning, through, being able to pass down our values? Because often traditional planning worships only the money. So money can be important, but we maximize income when it comes to traditional planning, avoid courts, reduce taxes. All of these things are super, super important, but they are only the foundational objectives of your estate plan. If you haven't done anything beyond this, that means you're not doing a full comprehensive estate plan. And that's what we'll be talking to you quite a bit today. So what's most valuable to you? Clients tell us, well, we think, of course, health is number one. How about my value? I want my values to be passed down to my kids. I want them to know. What about your relationships? All of these things are super important to people. Money is important, but so are these types of topics. So we want you to kind of look at wealth in a different way. And what does that mean? We want to be able to look at it from 4 different quadrants. Number 1 is core values, and certainly those are your deepest beliefs, your values, what you kind of came through as your culture, your background, that type of thing. Number 2 is your wisdom. So those are things you've accumulated through your life. Perhaps it's your career, your education, what lessons you've learned. Number 3, another way of looking at wealth is certainly what you give back. So what you give back to the community, whether it's causes you believe in, whether you volunteer a lot, whether you give a lot of your money to different organizations, that's also part of your wealth. You're doing something good for other people, and that's huge. And lastly, another typical definition of wealth certainly is your financial assets, like your house and your 401k and your life insurance, things like that. So how do you want to rank these things, right? Where is finance on that list? And so people might think, oh yeah, money is more important. And if you really sit and think about that, money is important. It makes us, it's obviously the means to an end, but how do we take that money and provide it to our families responsibly in a good way? And then how do we determine like our talent, our wisdom, and community? How does that factor in as well? Because sometimes, we take traditional planning. When you talk to a typical attorney, they're going to talk about protecting or maximizing your finances. Very important, of course. But we want you to think of this topic as legacy wealth planning. And what does that mean? We look at everything. We look at everything that impacts your family, and we want to kind of put all your values within the document so that we know your family will remember you and believe in the things that you stood for. So you do have to decide for yourself, like, what is the most important ingredient of a good plan, right? And I'll go through this towards the end, but just something to consider as we're going through this webinar. So why do most estate plans fail? So I love this graphic because it's pretty much true. You can certainly go online and lots of websites and other ways of getting your wills and trusts done, which is, of course, an option, let's just say. But a lot of times estate plans fail because those documents just aren't enough. They don't provide you what you need. Often there'll be missing provisions that really affect how that money is going to go. There's going to be no nursing home protection. You might not be able to get all the funding, which means putting all the assets into the trust. No updates for new laws. No remarriage provision, and then certainly the family legacy is not captured. Okay, so those are examples. I'm going to touch on several of those throughout the webinar so you can have a better understanding of that. We're going to do a case study today. We're going to talk about Bill and Mary Jones, and it's going to be easier to understand these topics through the eyes of a couple. Now, if you're single, it's okay. We're still talking about you. Estate planning is for everyone. We're just using this married couple as an example. So let's take a look at Bill and Mary Jones. So they have 2 adult children, John and Susan, and often we see the eldest child, Susan, she's pretty straight and narrow. She went to school, she did her homework, she became a CPA, she got married to Jason, and then they have a couple kids now. Okay, so your child, Susan, no problems. Now their son, John, I always call him the spirited child. Spirited meaning he's kind of beating his own drum, right? Living life differently. Didn't finish college, got into some drugs and alcohol, kind of gets into some jobs, but then he quits. So they're kind of worried about him because we don't know exactly what his future looks like. Okay. So that's John and Susan, their kids. Now, Bill and Mary have lots of options with their estate, right? They take their money, they want to plan for things. So certainly they can spend every last dollar. Now that's just up there as tongue in cheek, of course. We all don't know what our crystal ball is going to give us, right? We don't have the crystal ball that tells us how long we're going to live. But certainly I say to clients all the time, I say, it's your money. Definitely don't work so hard to try to leave an inheritance. You have to have your own life and your own happiness during your life. So it's not a requirement to leave an inheritance to your family. Number 2 is important to know. It's dying intestate. So it's a fancy word to say, I died, the person died without any will, no trust, no estate plan. Okay, so the statistic is about 65 to 70% of people have nothing written down. So if you're in that majority, You're not alone. But dying intestate just means that the state of Illinois, here in Illinois, has created a will for you. It's called the statutes or the laws of Illinois. And what that means is if you died with just a spouse, with a spouse and children, 50% goes to your spouse and 50% goes to your children. You might be thinking, well, wait a second, I should leave everything to my spouse. She's going to need everything. Why should it go to the kids? If you only have a spouse that survives you, then everything goes to spouse. If you only have children, it goes to children, equal shares. Okay. Now, if you don't have any of those relationships, we're going to go to your siblings and parents, equal shares, which sounds okay. Well, what if you don't talk to your brother Joe? Right? What if you have this estranged relationship? Another situation is, what if your parents don't need this money because maybe they're on Medicaid and they already are set to, in a nursing home, because the minute you give them money, they will be disqualified for Medicaid. So intestate is not always the best solution. Now, if you're single, no kids, and you pass away with no parents, no siblings, then we're going to create a whole big family tree to find out who you're related to, both on your father's side and your mother's side. So certainly something you don't want to happen. Number 3, you certainly have the opportunity to leave everything in joint tenancy. So what does that mean? Well, clients come to me and say, I just put my kids on my accounts and they're going to get it after I die. It sounds okay, but let's just give you an example. I put my son on my house because I want him to get it. So I put him on, and basically after I die, because it's joint tenancy, he gets the house. But in the meantime, let's just say a couple years after I do this, we have a falling out in our relationship. We don't talk to each other, and I want to sell my house. So now I have to call him and say, son, please come home and sign these documents so I can sell my house. So it's certainly something you want to consider, because now you're kind of giving up partial control of your house to your son. Okay. And then the worst part about it is your son, like maybe living life, having a good time, starts to drink and starts to drive and has a car accident. And then there's a plaintiff or a lawsuit filed against him. And now what happens to my house that happens to be in his name? It's now kind of exposed to his lawsuits and his liabilities. So whatever happens to my son, whether he has this car accident, whether he has creditors coming after him, whatever it is, my house is now part of that. So you don't want that to happen. Okay. Joint tenancy is only recommended for husband and wife, and certainly just if there's a need for it, but it's only very specific. So don't do that automatically. Number 4. It says to create a simple will. So certainly that's an option. You can give everything to each other and then to the kids, no problem. But I'll show you why that could be problematic. Number 5 and 6. 5 is creating a trust. Many people do that, whether they do it through their own means, draft it themselves, or through a lawyer, but often nothing has been transferred to the trust. So certainly it's kind of what we call bare bones, or it wasn't funded. So sometimes it's not enough. But if you want to make it more comprehensive, we'll talk quite a bit about family trust, family wealth trust today. So Bill and Mary have a lot to do on their list. They're going to retire, exercise, they're going to create a will, and everything gets created there, right? So the will says everything to each other, like I mentioned, and then to the kids upon the second death. Okay, great. So now, unfortunately, things happen. We don't always anticipate these things. So Bill has a stroke, and a stroke where he's debilitated, where it's pretty massive stroke. Now he can't act on his behalf, and he's unable to move that much. He's been paralyzed, and now we have to deal with long-term care expenses. So Mary is, of course, understandably freaking out and wondering, what do we do with Bill? What do we do with his care, and how do we pay for it? Because now she's looking at their finances and saying, wait a second, how are we going to pay for this? It's quite a bit of expense. Like I mentioned earlier, $10,000 to $15,000 of caregiver expense. That is 24/7 care. Okay. The 5 ways start us off with just using your money until you go broke, right? That's called the spend down period. And basically you're spending $10,000, $15,000 a month just to take care of one person within a couple. Okay. Number 2, maybe you bought some long-term care insurance and maybe that's giving you some coverage. But most people don't have this. It's a pretty expensive type of insurance. And they are very reluctant to even give you the money, even when you file a claim. But I would say there's also options to be able to get hybrid policies where you can get some life insurance with a rider that allows you to take money out for purposes of long-term care. So I don't do that for you, but I do have some great referral sources that can help you make that decision. Number 3, often people think Medicare is going to take care of them. But we all know that you do get your hospitalization and sicknesses through Medicare, and then you have a little bit of time at a rehab maybe paid for by Medicare. So I used to say that it's 100 days, but nowadays it's quite difficult to get on Medicare to pay for all your time. So often, say mom falls and breaks something, goes to the hospital, then has to go to rehab. And the rehab says, well, we can only keep you on Medicare depending on how often you are requalified for the Medicare. So it's not always a guarantee that you'll get a certain number of days paid for by Medicare. The 4th way of taking care of long-term care is Medicaid. And most people have a very, just maybe a limited amount of education when it comes to Medicaid. People assume that you have to be pretty much broke when it comes to being on Medicaid, which is true. There's a lot of laws, a lot of rules when it comes to qualifying for Medicaid. But there are ways to plan around it, and that's where we come in. It's called elder law planning, and we can certainly talk to you about that. How do we qualify for Medicaid sooner rather than later so that your family does not have to spend everything down to pay for long-term care? Number 5 is aid in attendance. So if you are a veteran and you served our country, there is a way to maybe get some extra benefits through that. Okay, so that's another option. So there's only 5 ways to pay for this very expensive care. So those are the 5 ways. And Bill and Mary have neighbors that they saw physically deal with this particular issue. So it's Ralph and Ruth. They live next door, right next door to Bill and Mary. And basically they realize, okay, we noticed Ruth is starting to not remember a lot of stuff, and she's diagnosed with dementia. So she lives, at home as much as possible, but eventually Ralph cannot take care of her anymore because it's almost too dangerous. So she goes into a nursing home. They spend down their entire savings. And then eventually the last 10 months of Ruth's care is paid for by Medicaid. Okay, so you can see that number. Their entire savings was $344,000. That was it. So it went down for a long time until Medicaid finally picked it up. And then when Ruth passes away, now Ralph and Ruth pretty much have lost everything. They might have to file for bankruptcy. Then Ralph's only income is his Social Security income. And then nothing's left to pass on to the kids, nothing to be able to inherit for the kids. So that's pretty scary. So this is an example, very, very typical example of a husband and wife going through this scenario. Now, let's go back to Bill and Mary. We talked about Bill being disabled. So not only does Mary have to deal with the physical side of it, how does Bill get taken care of? But now she has to think about the financial side of this situation that she's in. So in order to be able to access Bill's 401k or IRA, because that is their biggest asset as a couple, she has to go through a court process. And it's typically called a conservatorship or a guardianship. Here in Illinois, it's more of a guardianship. And it's basically a court process to protect people who are mentally disabled. Okay. You might have recalled a few years back, there was a whole to-do about Britney Spears having her money kind of locked away and watched over by a judge in California. And that's basically it. It's conservatorship. Now, what happens here in this type of guardianship, the court process? Certainly, it's quite time-consuming, could be humiliating, courts in control, and certainly expensive. Okay, and it's ongoing. So we've had guardianships last 5 years, 10 years, because somebody has dementia and they're physically okay, but their mind is not there. So they're on this guardianship track for a long time. But as far as Bill is concerned, he has this situation. He has a stroke. He's debilitated for a few years, but eventually he passes away. Okay. And then now we have to deal with court again, because in Illinois, if you have at least $100,000 of assets in your name personally, we go through what is called a death probate. Okay, so death probate is something you don't want to have to go through. It's pretty intense. It's a way to resolve disputes, of course, pay creditors, create an inventory, appraise the assets, and eventually everybody gets their money. But it takes a while. Okay, there's some disadvantages of probate. Certainly, probate can be quite expensive. You can see all the different expenses there. Certainly, attorney's fees are the most expensive thing on that list. Okay. It's time consuming, about a year and a half is what it takes. Here in Illinois, as far as the expense, it's called reasonable compensation. And I would say it would start out at about $10,000 to $15,000, and then it goes upwards from there because it depends on how much fighting there is, how many claims are filed, all sorts of things. It is time consuming, like I said, a year and a half to 2 years. It is open to the public. So all the court documents are filed with the court, and that anyone can take a look at it. So the information that's on those documents are where your beneficiaries live. So we have their addresses there. And then we also have to put in the value of their inheritance. So I always tell people, man, if that kind of information is public record, it's just a recipe for scamming. Now somebody knows you're going to get an inheritance and where you live, they're going to scam you. The other disadvantages is if you have real estate here in Illinois plus another state, like maybe you have a Florida home as well, we're going to open probate in that state as well. Okay. What about Uncle Sam, right? We want to make sure we don't have to pay more for taxes if we don't have to. So right now, we are having a higher exemption when it comes to estate tax. So only estates that are larger than 13 million, roughly, will be taxed. And then after 2025, it's going to be 5 million, that number. So most people will tell me, we're okay. But I always just say, let's put some tax planning in your trust because the government can certainly change their mind. Okay. Now, there is one issue. There is no estate tax if you are upon the first death. Okay. But if you are not a U.S. citizen, there is some requirements and a little bit of different laws for non-U.S. citizens. Now, will anyone remember Bill? Is he just a person on a family tree? How do we keep his life alive in the hearts of people? So there are ways to do so. And with Bill, we didn't do really good planning because all he did was that simple will that we talked about. So we went through a guardianship. We didn't talk about, we didn't protect anything from nursing home. We didn't protect from death probate, and certainly we didn't pass on values and life experiences. Okay. Now, after Bill dies, there's usually 3 worries that things maybe you don't even think about, right? Remarriage, lawsuits, and nursing home costs. Because if you recall, our next door neighbor, Ralph, he and Mary start to spend a lot of time together because they're both widows. And they start to spend a lot of time together to the point where now Ralph wants to propose to Mary and say, let's get married. Okay. So blended families are certainly a concern often to people. So how do we protect the family? Because we don't want Mary's assets to go down to anyone else other than her kids. So if we create a well-drafted estate plan, then we can make sure that the remarriage will not be important in a sense for money situations, because the money is always going to be for the kids and not to Ralph and his kids. Okay. This is the number one fact pattern when there's a lot of fighting in court. So it's usually blended families with children from previous marriage versus a surviving spouse of, which is typically like a second or third spouse of the decedent. Okay, so very common. This is a very common fact pattern. Another area that we want to protect Mary from is, what if she does need to go into a nursing home? What if she does get sued? How do we protect the assets? And we can do so in different ways based on the trust. Now let's go back to Mary. She has $700,000 of an estate. She gets the whole thing. Average person surviving typically is about 13 years. She lives another 10 years. Okay. But let's just say in year 5, year 8, whatever year it is, she happens to have her own health challenge, which is Alzheimer's. And the kids cannot take care of her in their homes, so she has to go into a nursing home. She's unable to pay her bills anymore. And now, once again, we're back in court. And which child will the court appoint? So if John and Susan are the choices, the judge doesn't know them. Obviously, to us, Susan will likely be the more responsible child. But of course, we never know. John can show up at court and say, I'm the more responsible one. And he could take advantage of his mom, certainly. So now 10 years later, we're going to bring back, or we're going to say that Mary passes away. And are there, any taxes due? So at this point, there's no taxes due because she's below the exemption. Okay. Now, will Mary end up as an empty name on the family tree? Hopefully not. But again, it's important to have your values, your stories available for your family. So this has turned out to be quite an expensive estate plan. So remember, they went to their local attorney and created a basic will. And this is the expensiveness of that, just basic planning. There was living probate, which is guardianship. There's death probate. There's nursing home costs. All of that could have been avoided, could have been reduced. Okay, so you can see there's quite a bit of cost, over almost $300,000 of costs that could have been avoided or reduced. Okay, if they had done their estate plan. Now, the financial maturity of children. Is the child ready for a lump sum distribution? I don't know. We think about John and Susan. How do we give them that money responsively? Because parents are worried about things. They're worried about their kids possibly getting divorced. They're worried about people, opportunists to take advantage of them. And then they're worried, what if they're in a lawsuit? What if there are creditors coming after them? So these are very common worries of a parent when the money is going to the next generation. Because even Susan, we thought she was this perfect child. We thought her marriage was perfect. Everything's fine. But she receives her $700,000 inheritance, puts it into her joint account, and soon enough, Jason files for divorce. Okay. And you wonder, okay, why does he get half of her inheritance, if not even more, because he could have just spent it all, right? Why should Jason get half? And so this is the part where clients typically will say to me, oh, no. I don't want my in-laws or future ex-in-laws to be getting this money. So they want to protect against them. Even John, he gets his $700,000. He purchases, the fancy car behind him. He buys a lot of things. And then all of a sudden there's a car accident and somebody's suing him. Now this money is available for those lawsuits. Okay. So in essence, we haven't done a lot of things for Bill and Mary when they only created a will. Okay. So all these things are things that we did not do. The ineffective plan. So there must be something better. And that's what we're here to talk about. So now we're going to bring them back and certainly talk about what is the better alternative. And that better alternative will revolve around a living trust. So I'm going to bring them back, go through all the scenarios, but the difference is they're meeting with us and we're going to create that living trust. We're going to make sure everything has been covered because not only do we want to protect the money, we also want to protect a lot of things like their values and their stories. Because Bill and Mary, they hold their assets currently as joint, right? So a lot of times you have joint assets. We have certainly some Mary assets and certainly some Bill assets. So all we're doing is creating this box, this trust, and moving all those assets into the trust. So Bill and Mary are all three positions listed here. They're the person who creates the trust. They're the people who are managing the trust, but they're also the beneficiaries. They're spending that money. Okay. So while they're alive, they have all three positions and they are controlling everything that is in that trust. So nothing has changed in their lives. Business as usual. They are in control. They can change it, amend it, revoke it, take it out completely. And their life is still the same. Their tax bills, their income tax, everything is the same. So why create it? Well, it's simply a standby device. What does that mean? It means that it's this separate thing from you as an individual, this box that protects you in case you're ever disabled, and then certainly upon a death. Because we don't want the courts to be involved. This is the box that helps you prevent that. And then it protects, obviously, your beneficiaries, your children, your spouse, and everybody. So during the time periods, Bill and Mary are fully in control. When Bill dies, Mary is in control, and then upon the death of both of them. Now, Susan is probably the person that they're going to choose to be in control. So now we're going to bring him back and we'll state that Bill has his stroke. Okay. Mary's, of course, going to have to figure out how to take care of Bill, but at least she won't have to go to court. She can get access to the money and pay for his care immediately. Okay. That's a big deal. That's really a big deal. And then when Bill passes away, do we have to go to probate? No. As you can see, assets are already titled in the name of the trust, and so we avoid another probate. And what about taxes? Well, the trust will protect them from unnecessary taxes, and that's huge. Okay, so very important to have that planning in there as well. Okay, back to Ralph. Ralph and Mary, again, spend time together. And even if Ralph wants to marry her, it doesn't matter. We're going to have provisions that say it's only for Mary and for the kids. It blocks anybody who tries to come in and get access to the money. Okay. And then, of course, nursing home costs and liabilities, we want to protect them from that too. So you can see we can also do that through the Family Wealth Trust, as well as a Medicaid Protection Trust. So I'll go into that in a few more slides. Mary gets Alzheimer's. Now, Susan's already appointed to manage everything for Mom, and basically they don't have to go through that guardianship again, and Mary can be taken care of, right? We don't have to go to court. We don't have to worry about John getting appointed. And that's a huge deal. Okay. So there's no legal fees because we're not doing guardianships and probate. But what about Mary's nursing home stay? Okay. She's spending a lot of time in the nursing home and can be quite a bit. So if you're interested in trying to do some Medicaid planning, long-term care planning, we can do that as well. It's called a Medicaid Protection Trust. And that is something that's super important and very specific to your scenario. So I don't want to talk about it at length here, but when you do come in for an appointment, definitely come in. We'll talk about this topic. Will Mary's estate have to go through probate? No, because once again, it's in trust. And look at all the different things we've been able to protect them from. Or protecting from guardianship, death, probate, taxes, lawsuits, remarriage, all sorts of things. Okay. And after they're both gone, everything's going to John and Susan. And basically, we're going to have two different types of trusts. One is called the access trust because Susan is very responsible. We're going to give her money in a separate trust so that she has access to it. But then her husband, Jason, gets nothing. So even if they get a divorce, this money is only hers. And that's a huge deal. Okay. The other type of trust is called a century trust. We're going to restrict John's distribution pattern because we're a little bit worried about him, right? So it's restricted and protected from divorce and from lawsuits. And certainly we can build in some incentives as well. So we can put in, he only gets money if he has a job. He only gets money if he is staying away from drugs and alcohol and all sorts of things, right? Now, if you do have a special needs beneficiary, we definitely want that money to go into what is called a special needs trust, because you do want that person to continue on with benefits and be able to access the money that you're leaving them. Okay. And so it's a very important part of planning. You might think, well, I don't have anyone right now, but we all are certainly, we have no crystal ball. We have no idea if there's ever a diagnosis about our health. So anyone can have a special needs. One more defining moment. How will you be remembered? So most people leave behind family disputes, court hassles, fees, taxes, but you can leave behind a plan that works. That's why you take the time to do this, okay? And we believe that this is really an important topic, that we have a whole system in place to take care of you. So basically there's 6 steps. Our first step is just initial consultation with myself or our associate attorney and really figure out what's the best plan for you. Our next meeting is just getting asset information. So we'll request statements and deeds so we really know what you own. Number 3, we're going to design your estate plan. So that's another meeting, and we'll make sure that everything is exactly how you want it. Number 4 is really important too, because we believe comprehensive estate planning requires us to look at your investments. So that is going to be a conversation about money and figuring out whether you're on track for retirement or if you're in retirement, how we can best help you in that. Okay. Number 5 is the day that you're going to come into the office and review and sign documents. So you might be thinking, man, I have a lot of meetings, right? Well, we believe in lots of meetings because we want to get to know you. We don't believe in just one and done. We want you to always be around as part of our firm, because we're going to have lifetime communications, updates, things like that. Now remember, knowledge is great, but you need an action plan. And often you come to these presentations and you're wondering, well, how much is this all going to cost? What's going to happen next, right? So I've already explained kind of the process and how it all gets done. Well, what we end up doing for a client is creating this type of binder. It's pretty hefty. It's a pretty big binder. And in fact, I'll show you. This is the physical binder that has all the different documents. It's pretty heavy. It's not just the one document. We also have all the different documents that are part of it, which is the will, the trust, powers of attorney, all sorts of things. We also offer some pretty unique, I doubt that any other attorney provides this. It's a personalized video of how this estate plan actually works, so that when you go home and you've already signed everything, you're able to watch that with your family and remember what exactly you signed. Okay. We also offer you a membership to a company called DocuBank. This gives you access to your medical directives 24/7. It's a big deal because you never know, you have a car accident, you're out of town, anything like that. We give you a flash drive, a thumb drive, a USB drive that has all of your documents in PDF format. So super important to have that as well. And then we give you a booklet to tell us more about you, about your family, your stories, your wisdom, things like that, so that your family knows a little bit more about you. If you are interested in learning more about Medicaid planning, which is a big topic, definitely let us know. You'll let Danielle know when you set up the appointment so we can address that topic with you. What if things change? Certainly things will change no matter what, whether it's in your life or whether the law changes. We'll be up to date and keep you up to date. We'll continue this relationship and always invite you to different seminars and things like that. So now I'm going back to that question we started with. What's the most important part of your planning? And I always say it's pretty simple. We believe that it's making sure what's important to you is actually in the estate plan. Okay. Often you won't get that through other attorneys or even doing it on your own. So you can have basic estate planning and try to do it yourself. Just make sure that you choose an attorney that's going to create it and do it the right way. Because a lot of times estate plans don't work. Trusts don't work. You might be thinking, what do you mean? How can it not work? Because a lot of trusts don't have anything in it. So your house isn't even retitled, your retirement accounts, your just investment accounts are in the trust. And that's important to have all connected to your trust. Sort of like a beautiful pen. If you don't have any ink in there, it's pretty much a worthless pen, right? And if you are going to shop around, go and talk to other lawyers, that's great. No problem. But certainly make sure that person has the right expertise. I mentioned earlier, we're pretty frank with fees. I'm going to share with you what it is for a typical estate plan that requires or that includes a living trust, powers of attorney, a will. That is our big, basically an estate plan that protects you for everything, whether you're single or married. What are your options? I always like to show this. You get what you pay for, just like everything else. I tell people we're not the Walmart of estate planning. We're not the low-cost provider, but we're also not downtown law firms, which can be quite a lot more expensive. So when do you avoid bargains? Don't do it with estate planning, is all I could say. So the total protection plan has, like I said, the main documents, a bunch of documents that come with it, and everything I just talked about. So that is the fee. Currently, that's the full fee for all of the different things that we create, including the trust and will and powers of attorney, everything that comes with it. And all of this will be discussed in more detail when you come in for an appointment. So just wanted to show you that as our flat fee. Often you'll get other lawyers that charge on an hourly basis. That's not us. We just want you to know exactly what the fee is. Sometimes people say, I don't really want that trust. I don't need the trust. No problem, right? We can talk about maybe having a will plan that's going to be a lesser cost, let's say. So it just depends. So come on in for the consultation and we can talk about that. Just don't let this happen to you, right? It's always that I'll take care of this later on. And this is a great quote. Only put off until tomorrow what you're willing to die having left undone. Okay.